Caution, Mr. Holly, let's have this lady that she's just designated go outside. I'll make a decision whether or not she's entitled to call.
Great. Judge, may I interrupt briefly? May I step downstairs to circuit court until Piper is called later if it's called?
You can go anywhere you want to between now and Piper.
Thanks, Judge.
Because I have no great confidence that we're going to get to the Piper case because it is last on the docket. So.
Yes, Judge. Thank you.
All right. If those witnesses are outside of the courtroom, then I am in a position where I want to hear this motion. We have two motions to quash.
And I still renewed and I refiled my motion for default judgment as well, Your Honor, for today. I put together the discovery and
well, let's first take up the motion to quash. You are here, if I understand, on the motion to quash, Mr. Mills.
Yes, Your Honor. I'm representing the town of White Bluff. Two officers were subpoenaed by Mr. Holly, and Mr. Potter's here on behalf of the county. A county detective was subpoenaed. Ready to take that up if Your Honor is ready.
Ready to go. I assume that's something we need to address on the front end, simply because of the fact that it will determine how many witnesses are available and what evidence is available.
Your Honor, the gravamen of the motion is that under Rule 45, non-party witnesses must be given 21 days to respond. These subpoenas were issued on October 20th, 11 days ago. So that's the main thrust of this motion as to the subpoena ducis tecum, which compelled testimony and the production of a pretty wide range of documents, evidence, and tangible things, which we have not had a chance to review. I believe the White Bluff officers were served last Wednesday, issued 11 days ago. Also, there are criminal investigations that are pending that involve both parties. So if the court denies our motion to quash as to these subpoenas and requires their testimony, we would ask the court to limit their testimony to any facts unrelated to those criminal investigations. So that's the basis. I don't know if Mr. Potter has anything to add for the county for Detective Lovell.
It's the same argument, Your Honor. I think that the county detective was subpoenaed to appear today and give testimony. The same argument Mr. Mills has made, asking for a lot of documents, records, papers, electronically filed information, etc. Certainly it was issued less than 21 days ago and served even later than that. And so I think there's an absolute right to declare the subpoena ducis tecum void ab initio because of the time frame. But if Your Honor compels the testimony of this officer, as Mr. Mills pointed out, it's our understanding that there are pending criminal investigations, that there should be some limit on what the scope of the testimony.
Mr. Holly, did you issue a subpoena?
I did. Couple of them. Two White Bluff City officers and then Detective Lovell, who is with the county on behalf of, that's what Mr. Potter is arguing. First off, Judge, I don't have any issue with the testimony going to whatever is civil in nature. I agree with that wholeheartedly. Part of the reason for the delay in these subpoenas is the lateness of the answers and the discovery that I got. If Your Honor's looking at my motion, when we get to my motion here in a few minutes, what you will know is that she answered the discovery late on a Friday, September 22nd. I had that Valdez case on Monday, a couple of other ones. I'm in the office on Sunday trying to figure out and make sense of the discovery. As I was looking at the discovery, I was taking her answers, looking at it, looking at the questions, flipping it over upside down and doing that thing. And I left her answers upside down on my desk when I ran out of there late Sunday night to get everything prepared. When we came to court last time on the default judgment, the answers that were filed with the court didn't include her written answers. I've corrected that today in my filing. I put everything together, explained that in my motion, and it's all there. It's still grossly deficient. I still want to take up my default judgment momentarily. Part of it, if you will look, and I can pass it back, but part of the problem that I had was when she answered the discovery, when I wanted to know where all of these items were. In this case, this motion for contempt is about her cleaning out his house. You heard the testimony of the officers already. But I get this with typeset that is, I don't know, 1/8 of an inch maybe. I had to get my magnifying glass out to look at it. It's riddled with some of these things now she's claiming she gave to the officers. And there's some different kind of stuff she gave. I don't know why you would need, there's like a sugar tester for your blood. There's some things in there. I have no idea why they would need that in an investigation. But she claims she gave it all to Officer Suddeth, Chief of Police in White Bluff, Chris Fulcher, and Steve Lovell, detective. My question for them is, do you have it or do you not have it? Is she telling the truth? Is she not telling the truth? My understanding, I expect the evidence will show, Officer Suddeth said whatever he got, he gave to Detective Lovell. Chris Fulcher's out there with one air tag he said he had, and that was all that he has. And that's what the evidence is going to show. Detective Lovell says he has a couple of boxes of things out in the car that if, told to come in or wants to, inquire about that, he does have those things. But that was the reason for the lateness. By the time I had a chance to look at her discovery and determine that from the 22nd of September late in the day, which I think if I calculated right, it's about 10, 12, 13 business days. By the time I had a chance to read her discovery where she's now saying that some of these items went with the officers, that's when I said, well, we may need the officers here to figure out what exactly she gave. I've spoken with, and Detective Martin, Troy Martin is in this, I've spoken with him. She claims there's a lot of stuff given to Sheriff Eads. The evidence will show with Detective Martin, he investigated that. Sheriff Eads didn't have anything. There's a couple of things that Detective Martin's had. He's been here the entire time. I haven't seen him this morning. I hope he comes. I may have to call him. But the basic gravamen of what I'm after is not necessarily for anything criminal. It's just for these guys to testify as to what she actually gave them, see if it goes to the truth of what she's saying in her discovery. The discovery answers were not signed. Again, that's part of my motion here in a few minutes. They're not under oath now. They're nothing but just pieces of paper that were given to me. But that is what she has told me, and she gave it to me months late. I filed this discovery. I think the discovery is 6-7 months late. I haven't looked at it in a little bit, but it was very late from the time she gave it to me. But I was scrambling to get them issued when I did based on what she told me. I'm gonna ask that they stay and at least provide that testimony to the court. They are here.
All right, Ms. Claiborne, you want to come to the podium? And this is, all I'm hearing right now is the motion to quash that's been filed by the town of White Bluff and Dixon County on behalf of these witnesses that have been subpoenaed.
Yes, Your Honor. The reason I wanted to take this stand is I want to discredit several things that Mr. Hawley is saying. I believe
we're not arguing the motion. We're not arguing a motion for default. Focus on just the motion to quash the subpoenas that we issued. Did you issue a subpoena for these two officers?
No, Your Honor.
You did not issue a subpoena?
No, Your Honor.
Then have a seat. Since the subpoenas were issued by Mr. Hawley rather than Ms. Childress Claiborne, it is this court's opinion that rule pretty clear, as was set forth in the motion, that Rule 45.07 of the Tennessee Rules of Civil Procedure is styled, and this is important, protection of persons subject to subpoena. The purpose of the rule is to protect people who are being subpoenaed that are non-parties. Subsection 1 of that rule states as follows: a party or attorney responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden or expense on a non-party witness subject to the subpoena, and shall provide the non-party witness at least 21 days after service of the subpoena to respond, absent agreement of the non-party witness or court order. Now, in my opinion, I am of the opinion that it is that rule would prevent the witnesses who have been subpoenaed to produce any documentary evidence, period, unless they've been given 21 days. But I don't see anything that would prevent them from being subject to subpoena to testify in person, and therefore I will grant in part your motions to quash as to the production of any records, any kind of documentary proof, but the witnesses who have been subpoenaed can testify as to non-criminal matters. And Mr. Hawley has made that clear. That's what he intends to do. So their testimony will be limited to non-criminal matters, and if either of you wish to remain during their testimony to advise them, because since you are the attorney representing those witnesses, you have the right to remain during their testimony to ensure that they are not exceeding the civil portion into the criminal investigation. I don't want to turn this into a preliminary hearing for the criminal cases, and I'm not going to allow that to occur. So, go ahead.
Thank you. We'll advise the witnesses.
All right. Now, Mr. Hawley, have you argued sufficiently your motion for default?
Judge, I got a few more things to add. The court should have filed October the 5th from me a motion for default judgment. And this is, I think, more or less the second, maybe third time we've taken this default judgment up. Every time that we've taken it, she's done a little something to carry it a little more further and get it continued. The bottom line with this is she's not answered her discovery yet. And attached to that motion, you should have everything that I got from her at this point. I looked at it closely. And again, the last time I was in court late on Sunday trying to prepare for everything, and she dropped this off at the last minute for our hearing purportedly on that following Monday. That Friday afternoon she came in, I was looking at the questions like we do, looking at the answers. I was flipping them over upside down and doing that on my desk. Looked at them really quickly. Didn't have time really to read the small print of the other answer, but I didn't flip that one back over and put it back in and have it in that stack to hand to you that following Monday morning. But I do now, and the answers are all there. I had prepared a deficiency letter at that time for Ms. Childers, and I stand behind my deficiency letter. It was still accurate because when my staff had looked at this for the deficiencies, that they had looked at her answers. The first thing I'm going to point out is in the 6-7 months or so since these things have been filed and outstanding, she still has not provided a signed copy under oath as required under the rules. That was made plain in the deficiency letter. The deficiency letter was sent back out to her again. So she heard about it all that day that we were in here. She got the deficiency letter. These answers have not been signed. And if you look at what she's missing, she didn't put down any aliases, obviously I know her name, but alias, social security number, and driver's license number. And those are pretty stock questions, and I didn't get anything as far as an answer on that goes. See attachment, there's nothing in there. Please state your current employer as well as your last 3 months pay stubs. I got nothing. There's no answer to that question. And I would submit to the court, mainly we're arguing today about money in this motion for contempt. It's about the cleaning out of the house and all the things that when this court ordered that she would leave the home and have nothing damaged or destroyed. The court's heard enough to understand that's where we are with this motion. And she has a source of income here with her employer that ties into this at the very end if the court grants it as her ability to pay. And I don't have anything. I have confirmed with the office she does have and has had a job for quite some time at MetroCan. I can show Your Honor the staff footage of my cameras at my office. I believe she had a MetroCan shirt on when she dropped this stuff off on Friday. But she hasn't, and she refuses to answer that question. There goes on with bank accounts. There's issues with her father's estate, which again is money to her, which would affect her ability to pay. She's refused to answer those questions. Interrogatory number 22, I think, is important. Please state your witnesses, address, telephone numbers. There's nothing. And she comes in today and said, I'm going to call these witnesses. It'll be the news to me. First I've heard of it. And she refuses to answer that question about the witnesses and refused to answer about them in the overall case, in the divorce. It affects today as well. Of course, there's other questions here. I'm trying to hit the highlights. The request for production of documents, obviously the pay stubs are not there, tax returns are not there, business statements anything having to do with Facebook, and she has put quite a few things on Facebook regarding all of this. And there's nothing there. What she considers to be her separate property list, separate property owned prior to the marriage, recordings, anything of Mr. Claiborne, I have absolutely nothing of. And these are minus the recordings, I think. I don't know if there's any of that or not that she might have. But the rest of this stuff is all boilerplate discovery things that go to our issues here today. And it's the reason why things take forever is because you've kind of got to go off on a fishing expedition when you get into these motions or a final hearing when people don't adequately answer the discovery. I'm kind of in a hamstrung situation here. I do think based on the conduct of Ms. Childress and her flat out refusal to answer these, I'm entitled to a default judgment in some manner. I would ask that the parties be divorced today, that put on some testimony about the proof if you need it again from him, but the motion pretty well sums everything up and adds it up. Or the only other issue with the divorce is I think it's $42,000 some odd dollars worth of property that she's absconded with or vandalized at his house. And Your Honor heard hours of testimony on that, saw the pictures, saw the receipts, saw everything that we put up on the stand. But it's just not fair for her to be able to avoid the rules. I know she's representing herself, but this court, and she has been representing herself for some time, this court made it pretty plain, and it's in the order, that she was to provide a full, complete answer to the discovery the last time we were here, not to mention this time. And I've just failed to get anything that I can use. And again, the other thing that I'm getting, the court looks at the back of this where it says, she's listing and addressing that list that Mr. Claiborne did. I had to get a magnifying glass to help me out with that. I'm not as young as I used to be. My bifocals weren't working, but I submit to the court, if you see that, that's just another situation that we have to deal with in this case from Ms. Claiborne. And it's another way to just get a dig in as far as the whole process goes, but she puts it in font that's that size. Thank you, Judge.
Justice Claiborne, you may address the motion for default.
Yes, Your Honor. I guess I don't really
Happy anniversary. You just had your first year anniversary October the 3rd. So
yes, sir.
I'm sure it was a joyous occasion for you and Mr. Claiborne.
Well, it would have been, but unfortunately, a week after I was in your courtroom, I lost my job with Metrocan. They eliminated my position.
Well, I say that sarcastically because this was a 4-month marriage, and we're now a year into your marriage. You were married in October and filed for divorce. Mr. Claiborne filed for divorce in March of 2023. So,
Yes, Your Honor.
anyway, more like a 5-month marriage, but in any event, divorce has been pending longer than you and Mr. Claiborne lived together.
Yes, Your Honor.
And I want you to understand that makes a difference as far as the law is concerned on the length of your marriage.
Yes, Your Honor.
So I need you to address why you have not answered more fully the discovery pursuant to the order that I entered in August of this year.
Yes, Your Honor. So when you entered that order in August, you gave me 30 days to respond to Mr. Hawley. I did that. I delivered the discovery request in a packet on September 22nd. Furthermore, Mr. Hawley stated when we were in here last that I didn't submit my discovery responses at all, even though he was quite vocal in quoting my responses that I did provide. Now, Your Honor, when we were in court last time, you advised me that I needed to bring in my evidence, that I did turn it into Mr. Hawley, and those answers needed to be here today. Your Honor, I would like to present, I have a video on this thumb drive. 12:06 p.m. is when I walked those answers into Mr. Hawley's office. This is a screenshot of my answers where, in fact, interrogatory number 2, my social security number, 41151.
Don't say it out loud, please. This is being live streamed across the world. You don't need to put your social security number out there. Mr. Hawley, do you have any question about the fact that she produced those at your office?
I do. You have everything that she produced. I haven't seen what she's looking at here, but if she's going to.
Mr. Hawley.
Okay. And I'm going to disagree with you, Mr. Hawley, of the video where I handed it to Bobby in your office. There's a screenshot and there's my answers. And if you look at response number 22 that you previously called out to Mr. Wolf, I did in fact answer that as well. Not one of my responses was left blank. There's
Well,
no
again,
social
Judge, I
security
just need a
number.
little bit of time to compare this with what I've got. For that being the case. I did not get this. This is not something that I got. This court, and if you don't have it, I sent that to the court attached to my motion as to what I got. That says see attached.
Well, Your Honor, I have no problem if someone can instruct me on how to use the computer. It's on my thumb drive.
What is?
The video of me with those responses on the top page, walking those into Mr. Holly's office from my Jeep, walking in to the only lady that was in the office was Miss Bobby, and you can hear me telling her, this is my discovery from Mr. Holly. I did a screenshot of that video, and that screenshot aligns with my answers. My answers were on the top. I recorded that for a reason, Your Honor. I have been drugged through the unimaginable with this attorney and his client, and I have had to document and cover my every move in my entire life right now. I have the evidence to prove I turned in the responses.
Well, if you desire to try to demonstrate that video, you may do so if you have the type of equipment necessary. I cannot try your case for you, Ms. Childers-Claiborne. You have the obligation representing yourself since your prior attorney has withdrawn. It is your obligation to put on whatever proof you wish to do so. But I want to inform you of the following. On August the 24th, this court put an order down that stated as follows. It is therefore ordered, adjudged, and decreed that the wife shall provide full and complete answers to all discovery questions previously filed by the husband within 30 days of today's hearing date, August 24th, 2023, or sanctions may be imposed. Now listen to me as I explain to you, because if you had a lawyer, your lawyer would know this, but you're charged with the same knowledge of anyone else. Each interrogatory, I'm looking at Rule 33 of the .01 of the Tennessee Rules of Civil Procedure. Each interrogatory, which is what we're dealing with, shall be answered separately and fully in writing under oath. So none of these have been sworn to. Mr. Holly's allegation that you did not sign them before a notary or provide them under oath, and therefore, and that if they have not been fully answered, then under those circumstances, they don't comply with the court's order. The Rule 37.01 is what Mr. Holly is referring to as far as what he's asking for: default judgment, failure to make or cooperate in discovery sanctions. And basically, it provides that if a person fails to provide the answers under interrogatories that were required under a court order, that an evasive or an incomplete answer, for purposes of this subdivision, an evasive or incomplete answer is to be treated as a failure to answer. It allows the court to make award of expenses for the motion. Failure to comply with a court order. If a party fails to comply with an order regarding discovery, or permit discovery, including an order made under the previous order that I've done, then these are what the court can do. An order that the matters regarding which the order was made or any other designated fact shall be taken as established for the purposes of an action in accordance with the claim of the party obtaining the order. In other words, basically it says it's not a default judgment, but it basically says whatever Mr. Holly and his client say is the truth is to be taken as the truth. Paragraph B, an order refusing to allow the disobedient party to support or oppose a designated claim or defense, or prohibiting the party from introducing designated matters into evidence. In other words, I can simply say, because you've not fully completed your discovery, that you can't introduce any evidence on these issues that are before the court. Paragraph C, an order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding as any part thereof or rendering a judgment by default against the disobedient party, which is what he's asking me to do. In lieu of any of the foregoing orders, or in addition thereto, an order treating as contempt of court for failure to obey any order except an order to submit to physical or mental examination. And then where a party fails to comply with an order under 35.01 requiring a party to produce another for examination, that one doesn't apply. So you see what the rule provides is pretty clear. You can't just submit a bunch of stuff and say, I've answered the discovery. Your answers have to be complete, directly responsive to the questions that were asked, and under oath. And in this case, those things have not been done. So whether or not you delivered some documents to Mr. Holly and have a video of it is not really the relevant issue. The relevant issue is whether or not you fully answered those discovery questions and whether or not that constitutes a violation of the order of this court regarding discovery entered in August, and whether or not I'm going to then allow you to put on any proof regarding those issues.
Yes, Your Honor. And I'm sorry, my point that I'm making is I answered every question Mr. Holly asked me. There's a printout. Mr. Holly has my documents. What I'm stating is on this thumb drive, those answers were on the top page because I knew he would pull this. And I walked them into his office and physically handed them to Bobby. And she acknowledged and took them. I answered every question that came my way, and I answered it within the time frame that you advised me to issue it in. The reason they are not notified, I have been very vocal since March that my name is not Amy Lee Childress Claiborne. My legal name is Amy Lee Childress. I do not own one government state ID with the name Claiborne on it. You have to have an ID to get something notarized. Mr. Holly is fully aware of what my name is. When he's sending the letters to Metrocan, on the outside it says Amy Childress. On every motion inside.
And you think that prevents you from appearing in front of a notary public under the name Amy Childress and signing the documents under oath?
Your Honor, I signed the documents that I gave to him. I do not have an ID that has the name Claiborne on it.
I'm going to take a recess. Mr. Holly, you compare what she's producing. When I come back, if she's able to produce a video of it, I'll allow her to play it, and then I'll make a ruling regarding. I'm going to necessarily have to examine what it is that you've asked and what her responses have been to determine whether or not she's in compliance with that. So we may not get started before lunch if I have to review all of that.
Yes.
We'll take a recess and allow this to take place.
All right.
All right. Mr. Holly, you've had an opportunity to compare what Ms.
I have.
Childress.
It looks like a different typeset, or maybe that's the way she copied it. And that's what I was saying. I hadn't seen this before because of the stretched out typeset. I don't know how she took a picture of this thing. I've included this in my motion. This is in there, but it still doesn't answer, in my opinion, any of the questions that I brought up. Now, if you look at this interrogatory number 2, she states 102B West Hills Terrace, Sidney Claiborne. There's 2 numbers after that. I don't know whether that's her social security number, Sidney Claiborne's social security. It's that for the answer to that question. But outside of that, I'm still prepared to go through these line item by line item with several things that she's not produced, including the witness list, including all the other things that I've mentioned. And they never were signed. She hadn't produced that. They've not been signed. They've not been affirmed under oath by her as required by the rules. But this is a different picture of what she dropped off, but it's in my October 5th motion. That's exhibit, I believe it's exhibit B, what she actually returned. So I still stand behind, as far as a list of everything that's not appropriate. If she's going to testify or whatever, that's her social security number, I guess that would be one answer to, again, the 2-page deficiency letter that's still outstanding. I don't know how the court wants to do that, but if we need to go line item by line item, I guess I can.
What the board wants to do is to finish this case because this case has been pending for far too long, considering the length of time these parties were married. So there's no question but that these answers do not comply with the rules of civil procedure, nor do they comply with the court's order regarding the requirement that she fully answer those questions. As a result of that, courts considered all of the different sanctions that can be imposed on this, and what I'm finding is that the most appropriate is to refuse under subsection 37.02 subsection B. The court finds that the defendant should be prevented from and prohibited from introducing any evidence regarding the matters that are requested in the discovery that you have filed, and therefore she will not be allowed to introduce evidence on the issues that were raised in your discovery request, and you may proceed with your case. But I'm not granting a default judgment. She'll be able to testify about grounds and so forth, but as far as introducing a lot of evidence that's set forth in your discovery request, I'm not going to allow her to do that because it's not being complied with the order. You may call your next witness, Mr. Hawley.
Can I have a moment with my client? Just a point of clarification, as far as the answers not being signed, all of those types of things, she's not going to be able to put on any evidence for any of the questions that I've asked.
Correct.
And that's for today as well as,
That is correct.
unless she remedies it at a final hearing. I would then call Colin Deaver. He can be my last witness to call then.
Ms. Childress, I understand that you may not agree with my ruling, but the fact of the matter is that the rules require that those answers be filed under oath and that those are sworn to. And the reason for that is that the opposing party may rely upon them as an accuracy. Where the rules require it, there's no provision for me to waive that, and as a result, your answers were not sworn to. I understand your reasons why you've given them, but rather than grant a default, simply a default, I'm simply saying that you cannot you cannot put any proof on regarding those issues that were asked about in the discovery request.
Yes, Your Honor. I think the problem that I have with it is I have the evidence to prove that Mr. Hawley has been lying in the last 2 court hearings, and it's on my thumb drive, and regardless of what Mr. Hawley wants to state, I do have that factual evidence that I did answer the questions. The way those were typed out, the reason it has an address, my social security number, and my driver's license number, if you read the interrogatory questions, they correspond with what was provided. I did not feel the need to retype those, but I'm fine with not using any of my information. I do have every bit of all of my documents to support that I did not cause the vandalism. My witnesses are here, and I will need the court to allow time because I do have videos as well as a lot of documentation.
You understand what I've just ruled, that you're not going to be allowed to put on evidence regarding the issues that Mr. Hawley asked about in his discovery request.
Your Honor, Mr. Hawley did not ask
Number
about.
one, when I am talking, you need
Sorry.
to be quiet. So we're going to consider whether or not those questions were asked, and I'll decide whether or not. Raise your right hand and let the clerk place you under oath.
Do solemnly swear or affirm that the truth, all truth, and nothing but the truth so help you God.
All right, if you will, sir, state your name for the record.
Colin Patrick Dever,
Mr. Dever, what is your address?
6501 Harding Pike, apartment T14, Nashville, Tennessee.
What is your last name? I'm sorry.
Dever. Dever rhymes with never.
Okay.
Never Dever.
Pull that, basically that microphone towards you a
Sure.
little bit so that it picks up, please.
Is that better?
That's better.
That's
Okay.
better. You want to spell your last name for the court?
D-E-V as in victory, E-R.
All right, thank you, sir. You know Miss Childress, correct?
Yes.
And y'all at one point were pretty good friends.
Yes.
I mean, she came to you with all these issues that she's dealing with Mr. Claiborne, and you guys talked about all of those things, correct?
She didn't come to me to talk about Mr. Claiborne. I found out about it after she asked me to pick her up from the hospital. And on the drive home, that's when she told me.
And you had spent nights at Mr. Claiborne's home.
Yes.
You'd stayed there for how long?
Every week I would spend like a few nights so she wouldn't be alone because she was concerned.
Mhm.
And, but I had, have my own place and my cat. And so I needed to get home and do things. So,
At one point, you became estranged from Miss Claiborne, did you not?
we had a bit of a falling out and, but
Is it because she wanted you to lie to
I
the,
object, Your Honor. I don't even know how Mr. Hawley can say that there was a falling out.
Number one, you have to object on a legal basis for an objection. There is no legal basis to say that you don't like the question he's asked. So overrule your objection.
I'm sorry, could you?
at one point, she was requesting that you lie to the police and file a false report about something that Hunter Anglin and Chris Lashley, the two officers that had previously testified, something that they had done. Is that accurate?
Not that I recall.
You don't remember anything about that at all?
I do not.
So
Our falling out.
you're saying that she never wanted you to make a false statement to the Dixon County Police Department?
Not that I recall.
Not that you recall?
No,
You think you would recall something like that?
I would think so.
I want to plug in here and put something on the screen if the court will allow. And if I can plug in. I'm going to show you a text message. I want to ask you if you recognize this text message.
Yes,
You wrote this, did you not?
right.
Can you read that for the court, please, sir?
She wanted me to make a statement against the Dixon County Police Department. I would not do that as I thought they did nothing wrong.
Well,
But
I'll show you another Facebook post and ask you if the last paragraph is something that you wrote.
yes,
That's on your Facebook account,
mm-hmm.
and you wrote this.
Yeah.
Can you read that last paragraph for me, please, sir?
She wanted me to say the officers did something wrong. I said I would not agree with that.
No, the last statement, being a good Christian, that paragraph right there.
Being a good Christian, I find it hard to bring myself to use this kind of language, but she's fine.
This statement, and I'll ask you if you typed this statement.
Yes.
Can you read that statement for the court, please, sir?
I'm going to kill this. See, I just got subpoenaed. This crazy doesn't want me to understand how much drama can one person create. Don't pay me back the $1,000 I lent you. Just leave me the hell alone.
You had lent her actually money, correct?
That's correct.
This statement as well, sir. Did you type this paragraph?
Yes.
Can you read that paragraph for the court, please, sir?
I'm over this no talent starting up trouble again. I just caught a call from the Dixon County Police Department about the complaint brought up against the officers, and my name was mentioned. What you need to do is pay me back the $1,000 I have lent you and leave me alone.
You got a call from the Dixon County Police Department about a complaint brought up against the police officers, and your name was mentioned. What did the Dixon County Police Department ask you about that?
Did I recall anything inappropriate? I don't remember it was a female, I guess, sergeant and I said,
You're not,
no, I didn't recall anything that I felt
Do you have an objection?
inappropriate.
Ms. Childers?
yes, Your Honor. This question is actually in part of a criminal investigation, which is part of what the other two attorneys spoke about. Can I have them intervene and see if the question is allowed?
Holly?
This is non-hearsay, Judge. It goes directly to Ms. Childers' credibility. She's asking Mr. Dever to get involved in filing a false police
The
report.
objection is as to the question that his conversation with the Dixon Police Department. He's reciting what he was being asked by the Dixon Police Department, which is a hearsay statement that they're asking, the question from them asking him, and his response would be hearsay. I sustain an objection. I don't think that really has a relevance anyway, but it is hearsay. Sustained.
That's all I have. Thank you, Judge.
Ms. Childers, you have the right to ask questions of this witness. It is not a point for you to argue with him or to make statements. You can ask questions in the form of a question if you wish to do so. Do you wish to ask any question?
Yes, Your Honor.
Come to the podium and you may ask your question.
Colin, how would you explain our relationship?
Well, we've been friends for 9 years. We met at a fundraiser raising money for a social service organization, and we just clicked. And, spent Christmases and Thanksgiving at your place and with your dad, and it was very good.
How would you describe my emotional state with everything going on? Is it a way that you had seen me in the past?
Judge, I would object to the relevance. First of all,
State is not relevant. Your emotional state is not relevant to the grounds for divorce or to the issues regarding property.
Yes, Your Honor. The post that Mr. Hawley showed said several times that I was crazy, and that's why I was asking the question.
All right, well, I'll overrule the objection, allow it for that limited purpose. She's trying to rebut the statements by Mr. Devers as to her mental state, so I'll allow it for that purpose.
No, and I was just so mad at you over that damn parrot of yours that I was watching that I lashed out inappropriately and used language that I should not have, and I apologize.
Thank you. Sorry, give me one moment. I just need to think how to word it. Did I ever ask you to lie to Dixon County Sheriff's Department?
See, I'm not recalling that you ever asked me to lie. I was just furious, and maybe I worded it inappropriately and wrong. I was just really mad, as you can tell by the text. So,
Without answering or providing any details of the investigation, can you state, did Dixon County Sheriff's Department indeed reach out?
yes, it did.
Did I ever reach out to you one time asking you to say anything to Dixon County Sheriff's Department?
I'm not recalling it.
During the course of everything that has gone on, have you, I know you've had some medical issues. Were you ever under the influence of alcohol or any type of, prescribed medications when these messages were typed up?
No, I was just angry.
And I know you were a little shocked about how those messages came up. Can you tell me, did you provide those messages from your messenger to Mr. Hawley in the text messages?
Judge, I'm going to object, first of all, to the relevance of how they were there. They were there. And secondly, it goes with the discovery. I mean, I well asked to provide everything having to do with any sort of social media, anything with witnesses, all of these things that she's not answering.
Sustained. Witness will not answer the question.
Have you ever shared your social media information with anyone?
Again, Judge, same objection.
So the question is, have you ever shared it with anyone?
Yes, Your Honor, because the point I'm trying to make is Mr. Hawley, his client, has continued to stalk and harass not only me, but people in my circle, and Mr. Collin does seem to not be aware that anyone accessed his social media account.
Sustained, because this witness has testified he's the one who posted those messages. I don't think that it's relevant whether or not there is any other issues. Any objection?
No further questions.
Mr. Hawley, you have any redirect for this witness?
I do not, Judge.
Mr. Dever, you may stand down. You are released from your subpoena. You may go about your business, or you may have a seat in the courtroom if you like. Thank you. Mr. Hawley, you may call your next witness.
I have just a quick moment, Judge.
You may.
That's our proof, Judge.
Plaintiff is rested to proof. Ms. Childress, you have the right to ask to put on proof if you wish to do so. Do you wish to call any witnesses or testify yourself?
Your Honor, I'd like to call Detective Lovell.
You'd like what?
I would like to call Detective Lovell as a witness.
And Judge, I would object. There was a witness list that I asked for. The court has already ruled Detective Lovell's not on here anywhere as far as a potential witness. He's a subpoenaed witness for me today, but she didn't issue a subpoena for him at all. And I object because, again, it's in discovery that I asked for this stuff.
Your Honor, I answered the discovery questions. I did. And at the time of the divorce, the people that I were going to call as witnesses are the ones to testify to the abuse, what I endured during the divorce. What Mr. Hawley has filed is a separate contempt motion against me, where at the time items were removed from the house, I was not under a motion. More or less also, the divorce had not even been filed. I'm speaking to this in regards to, these are witnesses to what Mr. Hawley is claiming, and in the spreadsheet that I did send to him, and if he can't read it, again, it's on my thumb drive. I don't mind taking a recess, but Mr. Lovell is actually listed as a witness.
And what do you intend to prove through Mr. Lovell?
With Mr. Lovell was present, so was Detective Martin in the room when I had the meeting with CID at Dixon County. It must not have been false. There's my evidence.
You talk to me, don't talk to him. Tell me what it is that you think that you are going to prove through Officer Lovell.
Because Mr. Lovell was present in many of the meetings.
Doesn't matter where he was present. What are you wanting to prove through, what are you going to ask him? What are you planning to put on in the way of proof?
I want to ask him if he was present whenever the CID team was questioning me. There was an investigation. The previous law enforcement officer that he did bring to the stand confirmed that he was reprimanded for being unethical.
Judge, I would object to this because it's a gravamen of what you've already ruled in the motion to quash, that we can't get into anything having to do with the criminal investigation.
Well, Mr.
We
Hawley
highly contest the aspect of that domestic assault.
Something that's relevant becomes an issue before the court. It's relevant if it tends to make something more true or less true that is an issue before the court. We are trying a divorce case. We are not trying a criminal case. And as a result of that, unless it directly goes to the grounds for divorce or goes directly to the division of property, it is not relevant to the issues before the court. Whether or not this officer was present during the time that CID investigated or interviewed you is not going to prove anything that the court has to consider. It doesn't prove anything regarding the grounds. What you're attempting to do is to rebut something that you asked these officers about whether or not they were reprimanded. Well, but whether they were reprimanded or not does not go to the issue of whether their testimony was truthful or not truthful. It has to go with whether or not you feel like they acted professionally.
Yes, Your Honor, my point being is because Mr. Hawley was questioning if I had Mr. Dever lie to have him contact the sheriff's department, and I did not, and I wanted to show the proof of that. But as to Mr. Hawley's point about the criminal side, Your Honor, you're correct. This is a divorce hearing. It should be in regards to a divorce. What Mr. Hawley and his client are coming after me for is theft. And my entire box, again, you can see it's been through Sheriff Eads, the DA's office, Mr. Crouch, all the law enforcement in this county. All of my evidence is based on criminal activity because Mr. Claiborne filed a false police report on me about what was removed from the house, and even went as far as reporting a gun into NCIC.
We're getting into testimony. I think the court's going to allow her to testify in a minute, but she's arguing her case.
Mr. Hawley,
We're making those statements.
I'm going to allow her to call Mr. Lovell, but I'm limiting it unless it has some direct elements. You'll need to object to anything that goes beyond the scope, but I'm going to allow him to be called as a witness. Since I don't think I'm going to prevent her from calling a witness, but putting on the evidence is a different matter. So Mr. Lovell will be called as a witness. I'll allow you to object, and then I'll rule on it.
May I address the court briefly? You're talking about grounds for divorce, but today we're just here on a motion for contempt. This isn't the divorce trial. I'm not prepared to put on grounds for divorce today. I filed a motion for contempt because of the previous
Why
order.
are we trying? Let me say this. Does your client want to be divorced?
I would ask for default judgment for at least a divorce today at the end
You
of
want
the
to be divorced from this man?
absolutely, Your Honor.
They're granted a divorce today,
Thank you, Your Honor.
right now. Now, since we're not talking about grounds for divorce, the division of property goes without fault to, is to be equitable or fair without fault. So I'm not going to consider the fault of the parties, but it also goes to the classification of property as to whether it is separate property owned by one of the two of you before the marriage, or whether it was marital property acquired during the course of the marriage. So those are the issues that are before the court. So let's limit it to that. You've now been granted a divorce. So the issues of what happened and what caused it are not relevant to this court's proceedings anymore. We're now going to go to the issues of property division, which is only about who owned what and how much it was. Now, we've also ruled that you can't put on proof about the property issues because of my ruling regarding the answers to discovery. And if those were questions that were asked during the time that these answers to discovery were requested, then I'm preventing you from, under that rule, from putting on proof about it. So what I want to know is, do you have proof regarding any issue that is still before the court?
Yes, Your Honor, I do.
What are you planning to put on?
At the time that the discovery questions were handed over to me, I had never left the marital residence. So, Mr. Hawley, there's no way that he could have asked that question. He couldn't see into the future to see what this next motion would be. The motion was filed after the fact. What I plan to present to the court, I have hundreds of documents of receipts, proof that these are my items. I have video of what
Did you produce all of those for Mr. Hawley? All of those hundreds of receipts that you claim?
No, Your Honor, I was not asked to. I was asked specifically by the court to provide Mr. Hawley the spreadsheet. And I did do that. And I have a copy of the spreadsheet on my thumb drive if anyone has a problem with how to make it out. However, based on the witnesses that are here in this courtroom, Mr. Hawley was able to read that spreadsheet because Mr. Lovell is here to testify in regards to electronic devices that were handed into the city of White Bluff.
Well, if I can, Judge, interrogatory number 29
Have you filed the interrogatories in the court file?
and number 28, I have. And they're also attached to the motion that I filed for the 5th. The last time we were here, I gave them to the court as an exhibit, and then they're also attached as her answers. The questions are written out, and she's got a handwritten answer. And the request for production of documents, number 29, produce any and all documents under items you intend to introduce as exhibits into the trial of this matter. And again, number 28 says basically produce anything from your spouse to others, photos, videos, any other material in any other way relating to your spouse. But I think she's stopped from putting any of that on.
Your Honor,
And again, as far as something classified as marital or separate property, I think it comes into play today from the property that maybe she took. But as far as an overall classification of everything, I mean, I'm not really prepared to get into a divorce trial today. I just filed a motion for contempt because there's some $40,000 worth of stuff that's no longer there.
I've granted you a divorce. I'm referring you to a special master regarding the identification and classification of all of your property. And we'll let someone else take the time that doesn't have all of these other folks who are needing it. So each one of you will be required to post with the clerk and master a deposit of $1,000 towards the payment of the special master's fee. And then I'll designate special master. Mr. David Brogdon will be the special master for your case. He will determine and hold an issue. I will draft an order that refers it to the special master and sets forth the issues that are to be resolved by the special master. You've been granted a divorce that terminates anything except the division of property and the motion for contempt regarding those property items. So.
Mr. Brogdon will be allowed to look at the contempt as well and determine that, or?
It will be allowed to determine the issues of property and therefore and where those properties items are located.
Yes.
Your Honor, Mr. Hawley filed a motion against me in his motion saying that I'm entitled to be represented by counsel if I could not afford one. I no longer work. I do not have $1,000 to pay in this matter. Can I request that I have a public defender?
Don't get a public defender in a civil litigation. You can represent yourself. I'll reserve the issue of posting the special master's fee, but you will have to pay a special master's fee at the conclusion of the case. And this court cannot and will not devote the time that it seems to me would be required to sort through the mess that the two of you have created in your marriage of 4 or 5 months. And all of your claims in your box with evidence labels on it do not, don't particularly persuade me that these issues are relevant. But if you want to litigate them, I've granted Mr. Claiborne a divorce and you a divorce. So you are now able to go forward with division of property issues in front of someone who might have a little bit better, a little bit more time to devote to it. So I'm going to take a recess. I'm going to draft the order referral to the special master, and then we'll come back and I'll start the next case. So you might want to contact the next people in order.
Yes, Your Honor. Thank you.
I wanted to address an issue that I wasn't aware of at the point in time until I began to go through the file. Ms. Childress has never filed an answer to your complaint for divorce. There was no answer filed, no counter complaint. She apparently had some motions filed through her prior attorney, Mr. Baker, who filed on April the 4th a motion for an opposition to the motion for possession of marital residence. On April the 19th, filed a motion for exclusive possession of the vehicle. On April the 19th, he filed a motion for pending support. And then on May the 9th, Mr. Baker filed a motion to withdraw, and that was heard and granted. No answer has been filed to the complaint for divorce. No answer has been filed to your motion for contempt. And a party appears from the record according to the documents. So therefore, this court is revising the judgment that I previously entered. Your motion for default is granted based upon the fact that Ms. Childress has not filed an answer to contest the issues that are before the court. And a default judgment means that you, as though you never appeared in this court. And as a result of that, Mr. Claiborne is granted the motion for default judgment as to all issues that are raised in the complaint. And therefore, the court, having heard proof on those issues, grants your finding of civil contempt in the amount of damages that you have set forth at the prior hearing. You'll draft an order and submit that to Mrs. Childress. Ms.
Your Honor,
Childress.
I was never given the opportunity to prove that I submitted those responses.
But I want you to understand, this has nothing to do with the issue that you are talking about. This has to do with the fact that a review of the court's file, and the court speaks from its minutes, demonstrates that you have never filed an answer to the complaint as required by the rules. As many of the other shortcomings of the handling of your side of this case, the complaint alleges various items that you are guilty of all of these different things, and including inappropriate marital conduct, cruel and inhuman treatment. And it shows that you don't own any real property and that you are various properties subject to an equitable division. A default judgment means that you not having answered the complaint and raised those as issues, that there's nothing, and that there was no answer filed by you or Mr. Baker as to the motion for contempt. So therefore, you have not technically appeared in this court as a party, even though there were some motions that were filed on your behalf that were never completely litigated.
Your Honor, the divorce and the contempt are two separate issues. I answered the interrogatories like I was asked by the court. I provided those responses. I don't know how to do this, but I can't represent myself or hire an attorney when there's over 50 motions being filed on me in this courtroom. I provided my responses. I just wanted somebody to look at the thumb drive to see I'm telling you the truth. Mr. Hawley, it was pointed out numerous times in the last 2 court appearances that he did have my answers. He quoted them on your stand. I watched the YouTube video back. I did provide the answers, Your Honor. The divorce should be 2 separate matters. There was nothing removed out of that home while I was under any type of restraining order. When the devices and the information that I provided to law enforcement at the request of them was handed to them before the divorce was even finalized. I have my evidence to prove all of this, but I've never been given the opportunity to present it to the court.
As I explained to you earlier, it's not a question of whether you delivered or did not deliver something. You did not comply with the order of the court regarding the rules of civil procedure, which apply to you as they do to every other person. And I have, in this court's opinion, bent over backwards trying to assist you and trying to give you an opportunity to do these things that are required by the rules. Because of the fact that primarily, I just learned from my review of the file that no answer had been filed to the divorce complaint. I was in error in not granting a motion for default to Mr. Hawley. A motion for default means he wins because you actually didn't show up in the sense of a legal proceeding. And for that reason, it seems to me that there's really nothing more that I can do for you, because as a part of the divorce action, the motion for contempt was a violation of the statutory injunction. That should have required an answer to be filed by you, and although we had an extensive hearing, you have never technically appeared on that issue. You have not filed a response to it. You have not filed an answer to the complaint for divorce. So I understand you may not agree with my ruling, but my ruling is based simply on the law and the rules of civil procedure that apply to every person who appears in this court. You can consult an attorney. There are procedures that you can follow to try to address this issue in some sort of a motion that you might want to file if that's what you decide to do. But you may want to consult with an attorney about that first.
Your Honor, I don't have the money. Do I have the option to appeal, to have it heard in another courtroom?
You have every option available to you under the rules of civil procedure.
Your Honor, in the motion that Mr. Hawley filed on me in that contempt, it said that I have the right to legal counsel. It was signed off on.
It's because he filed it and gave you a notice of rights, but he's filed it as a civil contempt rather than a criminal contempt, which means you do not have the right to an attorney. Civil contempt means I'm not going to incarcerate you in jail And for that reason, you do not have the right to have an attorney appointed for you.
But Your Honor, it was listed as criminal contempt. That's why I didn't understand why it was in your courtroom.
I'll draft the order, Judge. For the court, I'll draft the order.
That is judgment of the court. She's not found in criminal contempt anyway, of a civil contempt on the issue of these items being removed. Even if it was just as a hearing on the division of property, she didn't appear in the divorce itself, so therefore this court is of the opinion that the plaintiff's proof should prevail. You can consult an attorney, you can consult the rules, you have every option available to you for someone who is disgruntled with an order that the court puts down. That is the conclusion of everything I'm hearing in this case.
Yes, sir. Thank you, Judge.
Your Honor, am I divorced? Am I
You are
divorced?
divorced.
Thank you, Your Honor.
Take your contact is your.
Ma'am, you can leave.
He keeps
You can
harassing
leave.
me. That's his attorney.
You can leave.
Sorry, Judge.